Aloha, I'm Richard Emery, your host this week for Condo Insider. As many of you know, those who've watched us before, the Condo Insider is a show about association living, both condos and homeowner associations, and what's going on in the industry and how we can make it a better place for both the board and the residents alike. And we have interesting topics, and I more often than not do a report. And today I would like to talk about kind of what's going on across the USA in association legislation and issues. Some of you may not know that I have been for about 10 years the federal liaison for CAI in Hawaii. CAI is Community Association Institute on legislative matters. So in that capacity, I would go to meetings nationally and get to hear from all of the people like me in the various states and the challenges they have. And I learned very quickly a couple of things. First, you can get a pretty good idea of where our legislature is going and what's going to come up in the future by looking at what's going on across the USA. And so that's an important thing, to have kind of a telegraph of what's going on and what challenges they have. The second thing I've learned, in many, many ways, Hawaii is so far advanced on legislation, where many of the issues that come forward in other states, we've addressed decades ago, in the sense that we have certainly a small island. It's been estimated that 38% of our housing in Hawaii is in some form of association, which means of the 1.4 million people, 560,000 or thereabouts live in a association, condo or otherwise. So anyway, we watch this very carefully as the industry, what's going on, and I thought it'd be nice to review what I see are some of the trends and what we can expect and how that affects condos in Hawaii. This past year, our federal government passed a sweeping $740 billion, I'm going to call it Go Green bill, that encourages states and businesses and associations to become more energy sufficient, self-sufficient, and encourage the use of electric vehicles and maybe solar panels as an example. And so, we're an interesting state because we've already adapted state policy that we want to be totally energy self-sufficient. And so many of our laws already have been focused on that particular issue. You should know last year across the United States, in all of the states, there were 257 bills introduced, or about 5 per state, pushing mandatory solar panels. Then there were 656 bills across the United States, more than 10 per state, pushing mandatory electric vehicle charging stations. And we're not going to be exempt from that. Back in, I think it was 2015, our state, because of the pressure to mandate electric vehicle charging stations, set up a working task force to make a report to the legislature on the issues affecting mandatory electric vehicle charging stations. And one of them is fairly obvious. Does the association, the building, have capacity with existing transformers and electrical supply to provide charging stations? And if so, how many? The idea has been in some legislation that you have to have one station for every parking stall. Well, that's a little bit unrealistic, because just the infrastructure of how a condominium may be built and what kind of electrical that was provided for in the beginning may impose a gigantic economic problem for an association trying to provide an electric vehicle charging station for every unit. But the concept is good. We want to provide as much energy from the sun without fossil fuels as we can. But we have to look at the fact that the truth of the matter is we still have organizations out there every year at the legislature in Hawaii pushing mandatory electric vehicle charging stations in every unit. Now, let me just tell you a brief story that I own a condominium on the island of Kauai, and it's primarily in a resort zone. So primarily it's a vacation rental type project. It's legal in Kauai, and it's legal in the governing documents. And of the 56 units, I'm going to guess 54 of them rent them out as a vacation rental. So anyway, the board in its infinite wisdom said, we want to put in 2 electric charging stations with dual ports. That means they could charge 4 cars. And they had the parking area to do it. And they had a space that was available that wouldn't interfere with the issues of guest parking or the private parking that is given to you in your deed. And so they went forward with this quest to say, okay, we'll go get bids. And they did. And they picked a vendor, and they did. And one of the interesting things about the vendor they picked, by the way, is the technology is so advanced that the new charging stations, the company installing them would bill the owners. And basically how that worked is you would go up to the charging station and you would insert your credit card and you would charge your car and provide information like your text number, telephone. So when in fact your car was fully charged, you would get a text and you would have 1 hour to remove your card so it's available to somebody else, or you would start paying $100 an hour fine on top of your the fee that they had for the use of the electricity and the charging of the car, which was all done by a credit card, and which you inserted at the time you decided to charge your car. Well, so it sounds pretty simple. Okay, we have the space. It's pretty easy to put it in. We've got someone who will bill it, and so the association owners aren't having to pay for other people charging their car. We have a methodology to make those cars have to move, otherwise they pay an enormous fine per hour. So that was 6 months ago. So we went to the electric company to get approval. They said, well, your transformer is not big enough. You have to put a second transformer in. Okay, the board agreed to do that. And then the electric company said, well, we need you to do a survey of the property to make sure that's really your property, even though it's impossible for it to be anybody else's property. So then we had to go hire people to do a survey. And so we're pending the results of that survey, but here we are going on 6 months anyway. We still, after we've agreed to buy the chargers and put them in place, still don't have chargers to put in 2 simple dual purpose charging stations in a convenient area for people to use because of the bureaucracy of this whole thing. And my prediction is, as time goes on, because as you know, in Honolulu anyway, the city council passed a mandate that every association has to do an analysis of what they can do or not do with regard to electric vehicle charging stations. And so you can bet as this sorts itself out and they put the pressure on more and more electric vehicle charging stations, that the demand for installation and the demand for product is going to grow, and you can expect prices to grow. So I would just say to all of you that I think we all recognize that the future is going to be electric vehicle charging. May not happen as fast as everybody wants it. May happen faster here in Hawaii just because of the nature of being in Hawaii and the solar. And I'd be the first to admit to you that I have a electric car that I charge in my garage at night, and I charge it every night, and my electric bill has marginally changed, and frankly hasn't changed at all because I put in 48 PV panels, and I now charge my car and do all the electricity for my house, including my pool and Christmas lights and everything else that goes along with it, for about $20 a month. So it's probably the wave of the future. So I would caution all of you out there that we're going to see next year at Hawaii's legislature more demand for associations to evaluate. On Oahu, anyway, the city council has already said you're supposed to be doing an analysis of what you can do. And I don't think it's feasible to say you're going to have to put a stall in every parking stall or a charger in every parking stall. The current law in Hawaii mandates that if an owner wants a charger in his stall, he has to pay for it. Well, of course, that opens up the question about, is there enough capacity? How long of a run is it to get it so he can have the charger? Then how do you know and make sure that only he is being billed for the electricity that that charger uses? It's a complicated situation, but when I look at universally where the United States is going across the country, certainly the pressure for solar panels and the pressure for electric vehicle charging stations is going to mount. And so I would suggest to you that associations, particularly those in Oahu, because of the ordinance, start looking at what they can do, because having a couple of charging stations where their shared use is better than not having one at all. And I think that the problem is going to be, as time goes on, being able to find enough people to install them and getting enough product to do so. Solar panels is kind of the same thing. It's very difficult to establish and put solar panels on existing buildings. I've seen them put over open parking areas, kind of like a lanai or a roof where they put solar panels. I see them in some smaller roofs. They put them in for a limited ability to provide some offset for the electricity charges. I think we all know electricity is going to go through the roof here in the next few months, if not few hours, because it's really a lot of pressure on electricity. But dozens of states have already passed laws on this. We've passed laws on this, and I would caution you that that's going to be again the big item. And even though we did a work study group who said it's hard for multifamilies that have been built to put in electric vehicle charging, these proponents of it don't care about that. They're going to continue to push, in some cases, unreasonable requests for a vehicle charging station to be put in, no matter what the cost may be. And I think we just have to be prepared that that's coming down the road. And every one of you who live in an association have got to start looking at this sooner than later. I think it's going to be much more expensive to look at it down the road. And the fact and the example I gave with the one on Kauai, okay, they have 4 potential ports because of the dual charging stations. Well, if they will have records of how much they're used. So if they're not used very often, it would certainly be a valid reason why they shouldn't be forced with the cost to put in more charging stations at this time. So it's a hot item. But let's look at some of the other laws that were passed. As I said earlier, you can get a kind of a prediction of the future when you look at the other laws that are passed. But on that note, because we're midway through the program, I'm going to take a 1-minute break, and we're going to come back and talk about some of the laws that were adopted in the rest of the USA and what I expect to see in the 2023 legislature here in Hawaii. We'll be right back. Well, I'm back again. I'm Richard Emery, your co-host today, trying to be a predictor of the future with regard to future laws. And as I said a moment ago, you can look at some of the laws that are being passed elsewhere and get a sense of what may be happening in the future. I want to begin by just talking about, very briefly, I did a show on this, the building that collapsed in Florida. And we all know that over 90 people lost their lives. The building collapsed in 9 seconds. And everywhere across the country, particularly Florida, they looked at changing the laws. The problem in Florida was that even though the board had identified the structural problems, they had a requirement under Florida law that they could not do a special assessment without the homeowner's approval. And even though that board tried to get homeowner's approval over years, where the cost of the repair went from 9 million to I think 15 million, they could never get the owners to approve the special assessment. And so, in essence, created a high safety risk for the residents. Now, you have to understand in Hawaii that's not true. Hawaii has very clear laws that says the board is responsible for maintaining the building, the property, the project, and the board has a fiduciary duty to maintain it. And they don't have any obstacles on doing a special assessment. They do have an obstacle if they want to borrow, where they have to get 50% of the owner's approval. But to do the special assessment themselves and let the owners go get their own financing is all currently within the authority of the board. And so I want to mention that to you because there is a case here in the Florida court that was called Lecor versus Star Lakes Association. Let me just read briefly the summary, a couple of sentences. The Florida Court of Appeals ruled that building restoration expenses in excess of insurance proceeds could be billed to all units in the condominium building, not just those that were damaged. Additionally, the board can impose a special assessment without the vote by owners to fund urgently needed repairs. So you can see this particular appeals court case said a couple of things. Number one, that you can assess all the owners for the repair, not just those that benefited from the emergency repair or the insurance proceeds. But, essentially, we already have that in Hawaii. As you may know, we have a state law that requires associations to provide various insurances, including property insurance. Those state laws require that the plumbing issues like ice makers breaking or sinks overflowing or whatever it may be are all covered under the master policy. And the current state law in Hawaii says that the board has the authority to allocate or determine who pays the deductible. It may be the unit owner who caused the problem. It may be because it's in a common pipe. It may be the 3 or 4 owners who benefited from the insurance policy, or it may be the whole association as deemed by the board. But what's clear in the Florida ruling was this argument that you can't fix the building because you don't have money went away. The board has a duty to take care of problems that come up. And that's the standard in Hawaii. You can't really just say, well, we don't have the money, we don't want to assess anybody, or I think that'll last longer. My experience is doing a lot of expert witness work is we're going to see more and more boards sued because they didn't take care of the business they needed to. And new buyers who may come in and get a special assessment may sue saying, you had the ability to fix this problem long ago. No one can predict that, but at least from Hawaii's point or from Florida's point of view, in the example I gave you, you can see the courts are leaning towards boards having an obligation to fix things, period, and they have the ability to make a special assessment, and that's supported by Hawaiian law. Now, moving on to Santoro versus Eagle Crest Estates Homesite Owners Association, the Oregon Court of Appeals ruled that a declaration imposes a duty on an architectural control committee to act in good faith in reviewing proposed plans, requiring more just an absence of fraud or bad faith. So what that really means is if you're reviewing a request by an owner for an air conditioner or a change that's maybe they're contemplating within their apartment, that you don't have the ability just to say no. You have a duty of good faith to make sure you've reviewed the application and have valid reasons why not to approve it. It's not uncommon for owners in condos to, so long as they're not load-bearing walls, to want to change their walls, remodel their condition, put in air conditioning. Maybe they're a person who has asthma, they need the air conditioning. So what this basically, this particular ruling by Oregon's appeals court said that you have a standard of good faith with regard to when you look at these applications and requests by owners. And we've seen that in our legislature all the time, where homeowners are complaining that the boards didn't treat them fairly and they didn't operate in good faith. So it's a fairly common thing that you need to look at your duty, what your authority is in your governing documents, your duty of fairness and equity, and address it accordingly. Next one is Tortosa Homeowners Association versus Garcia. The Arizona Court of Appeals ruled that after a foreclosing lien holder is paid in full, any excess proceeds should be given to the owner after all the other creditors are paid. Now, that's interesting because that really hasn't how it worked here in Hawaii. If you end up with a foreclosure and the bank forecloses and they get the proceeds and they pay themselves, and then they have to pay additional lien holders, such as the condominium association who had liens, they owe up to 6 months under Hawaii law of unpaid maintenance fees regardless. But if there was other excess funds, they could pay the rest of the maintenance fees. But more times than not, it wasn't clear in Hawaii law what happens with the excess funds, in the sense that lenders typically foreclose, they get title, they usually credit bid it, so they get it without a true bidding with people there at the show. So now they own the property, now they sell it in a post foreclosure sale. And since they're the owners, they had no obligation to share those proceeds. Well, in this particular appeals court case in Arizona, the courts ruled that no, that even though they foreclosed, it's not their money. So they had an obligation to address that appropriately by giving any excess proceeds after paying everybody else. And granted, that's not the case more times than not. There is nothing left. But that was how the Arizona Court of Appeals ruled. And we see more and more pressure in Hawaii's legislature on foreclosure process all in all. Next one was Warner Investments versus Dynasty Homeowners Association. And the Indiana Court of Appeal upheld the trials court decision to leave an owner's unapproved barn in place because there was no evidence of direct or ongoing harm to the community. The court did order the owner to pay the association's attorney fees. So in this particular case, applies more to homeowner association. There was a barn on the property that was doing nobody harm, but was in violation of the governing documents. But there was no harm to the governing documents or anybody there. And the Indiana Court of Appeals said, well, there's no harm to anybody. So even though it doesn't comply with the documents, they can keep their barn. And that's an interesting ruling because Hawaii has been much more strict on compliance with the governing documents. And so I'm not sure if that'll lead into something on that issue or not, but it's an interesting take because I see it, frankly, all the time where there's properties that the new owner inherited something that was structured or something that was done that was not pursuant to the governing documents. And the association takes the position, well, you got to tear it down. And the question in this particular lawsuit was, well, if there's no harm, why should they have to tear it down? And so that's an interesting issue because we got a lot of homeowner testimony against boards for being too restrictive. I teach a class on governance, and I would tell you very clearly that you have to look at the authority and then there's equity and other things besides just the written language of the governing documents. Then there's Belmont Association versus Farwig, that the Supreme Court ruled that the state law regulating restrictions on solar panels did not allow HOAs to prohibit solar panels. We have that already. If you're an association and you're an owner in a association, particularly a HOA or a townhouse where you have control of your roof, or there's a lot of CPR, single family home, the association cannot prohibit you from putting up solar panels. It gets more complicated with multi-floor buildings, because you may have 2 or 3 or 4 units sharing the same roof space as the 4th highest floor, whatever it may be. And there gets to be an argument about why should that unit who applied first get the use of the roof, and I applied second, so I don't get the use of the roof. So, but it's clear that the country and Hawaii is going towards encouraging every means possible for green energy. And finally, let's look at KISS versus Old Redneck Trail Homeowners Association. This is an Illinois course. A director was entitled to immunity for the things he said when speaking at a board meeting, so long as the things he said were not false. So, freedom of speech. So I guess the point is that the director can express his opinions, and so long as he didn't knowingly make a false statement, he's got immunity from an owner suing him that the statement was false. And a good example would be these RO 105Cs, these documents and the resales. A director may unknowingly say something that turns out to be false, and then he gets sued providing false information when the current law in Hawaii gives you some immunity, when in fact he didn't know and didn't have knowledge on the particular issue that was there. So that kind of summarizes where things are. In Hawaii, I'll tell you, we can see new legislation on mandated structural inspections. No time to talk about that now. That's got its baggage too. You're going to see amendments to Act 62 on interpreting the reserve law requirements, which were adopted under Act 62. And we're going to see probably some more emphasis by a small group trying to restrict proxies being used at annual meetings. So I can tell you in summary that your CAI locally here and Hawaii Council of Community Associations locally, as well as others, work hard with the legislature to make sure that the laws are balanced and address all the issues that are out there. So in summary, my answer to you about the laws, let's go green, baby, go green. It's all going to be about solar panels, electrical vehicle charging stations, and making those easily and accessible. And then there's going to be more laws trying to create more clean and pure meetings where boards can't take advantage of homeowners just because they have the power to be in charge. And so on that note, we've had a quick half hour. I hope you've enjoyed or learned something from this. I could talk about this at length based on facts and examples, but I wanted to give you kind of an overview of kind of where the world is going, and hopefully it's helpful to you, new board members who are out there. Start your vehicle charging station analysis now. But anyway, aloha, and thank you for watching Condo Insider, and hope to see you in another episode in a future week. Aloha.
Thank you so much for watching ThinkTech Hawaii. If you like what we do, please like us and click the subscribe button on YouTube and the follow button on Vimeo. You can also follow us on Facebook, Instagram, Twitter, and LinkedIn, and donate to us at thinktechhawaii.com. Mahalo.